case. David Colby out of Warsaw tried it. And when I said there's no published cases in Indiana, there is an unpublished case that dealt with this very topic. And it's in your handout there. Again, it's Garcia.
Doug, were you on the board when this one came down?
No, I wasn't there for the Garcia decision. Although I have handled a case involving this issue that was appealed to the full board, and not with the best result from my side.
Right, I'd imagine. Again, this case has no precedential value, although the 7 workers' comp judges in Indiana, they know about the case, but they just can't use it as precedent in their decision, and there is wide discretion within the state. We'll talk about that briefly as far as the single hearing members are concerned. Now, this Garcia case, primary issue is whether the Indiana Comp Board erred in ruling that the employer properly terminated Mr. Garcia's TTD, temporary total disability benefits, based upon his illegal status. Now, Mr. Garcia admitted that he was an unlawful resident of the U.S. after he received months of TTD benefits after he injured his leg at work. This eventually came out in discovery, as many times it does. Upon learning this information, boom, Owens Corning cut him off, pursuant to the statute that Joe just touched upon. Garcia appealed to the single hearing member about the termination of his benefits. Single hearing member reinstated Garcia's benefits, so Owens Corning appealed that decision down to the full board. Full board reversed the single hearing member's decision based on that previous statute, unable, unavailable to work, because it permits an employer to terminate TTD, again, when the employee is unable or unavailable to work for reasons unrelated to the compensable injury. And Garcia could not provide a valid Social Security number, thus that prohibited him from working. Indiana, that was taken up, Indiana Court of Appeals, they affirmed the board's ruling as well. Again, this case has no precedential value, but a lot of times it's thrown in my face when I'm faced with an undocumented worker. Hey Ed, you know, this Garcia case is out there, you know, I'm not paying your client wages. Usually we get it settled, again, before we test the waters or whatnot. I'll get some dough out of them in the long run for lost wage benefits, but again, this really hasn't been tested further than the Court of Appeals.
One of the interesting things about this case is the defense attorney. The defense attorney on this case is Daniel Foote. He's one of the hearing members now. So the question would be, is he going to reverse his own thought process in arguing the Garcia case when he's on the board? Doug can testify to that.
I think you'll find now that if you take one of those cases up, that Garcia doesn't make a good difference.
No.
I think you'll find that the full board is disposed to awarding the full monty if they think there was a legitimate connection.
Yeah, that seems the general tenor of at least the current system is, you know, at least up in this neck of the woods, is, you know, awarding compensatory benefits.
It's interesting to hear Joe comment about Dan's involvement with that case. In an informal discussion with Dan one time, he told me he thought that Garcia was flawed because it provides for terminating benefits. That while it works in that case, because Mr. Garcia had received some TTD benefits that were then terminated based on his worker status, that you have a case where compensability is challenged from the very beginning.
Right.
That doesn't work because it presumes that you've already paid it.
Right.
So what's the purpose of the federal law since the state law supersedes it anyway?
Federal law deals with federal situations and wages in regard to your normal wage.
Yeah, but
they're not talking about an injured party.
To the states, right?
The states can decide their own workers' compensation.
Right, so then, like I'm saying, what's the purpose of the federal law?
What's the weight of the federal law?
Yeah, what's the weight? You're writing a superfluous law that carries no weight, and you guys aren't like that.
You're talking about the federal...
Nobody's willing to penalize...
Talking about the Immigration Reform Act?
Federal law, yeah, because you're deferring to the states.
It doesn't defer the hiring to the states. It's illegal to hire these people. They've made it illegal. They're trying to create a deterrent to the employers to hire these people.
It's fine to say it's illegal, but if there's no penalties or anything to back it up...
There is a penalty.
And how often are those penalties imposed?
Every time what was it, Tyson Chicken down in Arkansas just got fined last year, I forget the dollar amount, but a large sum of money.
Well, I mean, if you
For
compare,
hiring
if you
illegals.
compare penalties to the exposure that's out there, then really what's the use of the law?
Yeah, the civil penalties are relatively low, and $375 to $16,000 per violation. I mean, it could add up if you have multiple employees, but how big of a dent it is in Tyson's law and whatnot, that's questionable.
Right.
And that IRCA was, specifically focused on deterring the influx, that employment magnet from Mexico and other South American countries into the states. It was very narrow focus. I mean, they could have enacted a broad encompassing statute, but I'm sure there was parties on both sides that were against
I'm
it.
just saying the federal, it looks good on the books, but if you're not enforcing it,
It's around the world.
I think what you have to remember, too, is this federal immigration law is completely separate and non-overlapping with the workers' comp law. If you have a federal law that overlaps the state law, the federal law is going to be preeminent, is going to trump it. But I think you're dealing in a situation where they're dealing with two completely different aspects of the immigration question. And unless and until they overlap, the federal law won't preempt. It's purely a state issue, and the federal government won't get involved in a pure state issue.
Right.
Doug is on pins and needles.
I wish I could give more explicit information, but I know the General Assembly in the session this year did pass a bill enhancing the requirements for the employment checks, a requirement that employers now use the E-Verify system to make sure that they're not hiring illegal, undocumented workers. What the penalties are and what part of the statute that's in, I'm not immediately familiar with. So it fits in with what Joe and this young lady has indicated, that the intent is to stop the employment, the illegal employment before it even happens, and it doesn't even address who's eligible and not eligible under workers' compensation based on their documentation status. So I know that the penalties have been strengthened in Indiana. I wish I could tell you what they are. But the business about trying to prevent the illegal hire from the beginning, before it even gets into the workers' compensation system, has been strengthened this year in Indiana.
Now, one of the ironies is that we're trying to deter this, but if you look at the unemployment situation of Mexico and the United States, and a lot of people don't realize this, the U.S. right now is 9.1. Some say the actual rate is about 16%. The unemployment rate in Mexico is about 5%. So actually there's almost a reverse migration that's been going on.
Now this slide here, again, it's an overview of the comp system. Broad discretion afforded the single hearing members that are dispersed throughout the state. You get a ruling in Lake County, same facts down in Marion County, completely different ruling. It depends on the judge you get and what their mindset is with regards to the facts. Again, clear lack of uniformity of decisions throughout the state and throughout the country in general. General tenor, as Doug and I were discussing in Indiana, is start to award these benefits, at the very least medical benefits. One of my recent cases that I was going back and forth with an attorney in St. Joe County was whether they even pay him as permanent partial impairment, which I thought was a ridiculous argument. They paid for his medical. He had a severe head injury, a piece of metal fell on his head, developed a hematoma. He's cut from here to here now, and you can see the stitches and the impression in his head. Luckily, he was able to go back to work, but he had a significant recovery period. Got him his permanent partial impairment and his medical benefits. And in order to effectuate any change in these systems, you got to go through the legislature. I mean, that's where the laws come from. If you want to change the definition of an employee or who gets benefits, you got to go to the General Assembly down in Indianapolis. This issue, again, hot button issue, comes down to public policy, humanitarian issues. On the pro side, for giving undocumented workers benefits, it seems unfair for these employers, especially ones that know they're hiring an undocumented worker, to profit off the labor of that individual. A lot of these illegal aliens, they do work that most folks don't want to do, and in unsafe working conditions as well, because they know they can get away with it. So the withholding benefits from the employee while the employer benefits off of their labor